Thank you, members. We will now proceed with the division on Amendment 115, and members should cast their vote now. The vote is now closed. Point of order, Fergus Ewing.
Presiding officer, my app froze. I would have voted no.
Thank you, Mr Ewing. Your vote will be recorded. Is Mr Gibson seeking to make a point of order or to speak?
I would have voted no.
Could you repeat that? But your microphone wasn't on halfway.
Yes, I would have voted no. My app also.
Thank you very much, Mr Gibson. Your vote will be recorded. Point of order, Neil Gray.
Presiding officer, just wish to clarify as to whether my no vote was registered, please.
Yes, Cabinet Secretary, your vote was recorded. Thank you. The result of the vote on amendment number 115 in the name of Rhoda Grant is yes 23, no 89. There were no abstentions. The amendment is therefore not agreed. I call amendment 233 in the name of Rhoda Grant, already debated with amendment 115. Rhoda Grant, to move or not move? Moved. Moved. The question is that amendment 233 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 233 in the name of Rhoda Grant is yes 23, no 88. There were no abstentions. The amendment is therefore not agreed. We will now move on to Group 3 on power to impose obligations in relation to large land holding. I call amendment 116 in the name of Ariane Burgess, grouped with amendments as shown in the groupings, and I call on Ariane Burgess to move amendment 116 and to speak to all amendments in the group. Ms Burgess.
Thank you, Presiding Officer. I move Amendment 116. Scotland's Land Register is a publicly searchable database of land and property that has been bought and sold, showing the price paid and the boundaries of the land holding. Indeed, those who have bought and sold their own homes will be familiar with the process, but many of Scotland's largest estates have not been entered onto the Land Register, either because the land simply hasn't been sold or because they've not been voluntarily entered onto the register. And my amendments 116 and 132 together adds a requirement that owners who have to prepare a land management plan must also ensure that details of their ownership are entered onto the Land Register. Indeed, I met recently with the staff at the Registers of Scotland to explain their process of transferring ownership records detailed on the old Sasines Register over to the new Land Register. But this is a slow process and will take many years to complete, if indeed it could be completed at all. My amendments in this group are a small measure towards speeding up that process, Simply put, any landowner required to produce a land management plan will also have to enter information about their land holding onto the land register. And surely they will be having to map their land anyway as part of making their land management plans. And this adds another trigger point for entering the land register in addition to the point of sale, and will bring greater transparency over the ownership of some of Scotland's largest land holdings. Having this information centralised and accessible, ideally in a cadastral system, is an important building block for introducing some form of land value tax in future years. Turning briefly to other amendments in the group, Greens will support Rhoda Grant's Amendment 263 that would support the creation of new crofts. We also support the amendments from Michael Matheson, 269, which clarifies the community engagement obligations on large landowners, and I wish to express briefly concerns that Edward Mountain's amendments in this group could weaken the obligations in Part 1. Thank you.
Thank you. I now call Rhoda Grant to speak to Amendment 117 and other amendments in the group. Ms Grant.
Thank you, Presiding Officer. Amendment 263 enables a community body to approach a landowner and ask that they consider creating new crofts. The bill already allows for a community body to request land be leased. However, in the crofting counties, the creation of new crofts is much more in keeping with local land management. While crofting is facing huge challenges now, in the past it has helped retain populations in rural areas, gives security of tenure, and the very nature of crofting is environmentally friendly and community focused. Amendment 133 is very similar, but given the Scottish Government help draft 263, and I'm very grateful for that, I will not move 133 in the hope that the Scottish Government support indicate that they will support 263. Amendment 117 is a consequential amendment to 263. Edward Mountain's Amendments 16 and 118 are very similar, looking to ensure that regulation is proportionate to the size of the land holding. We're minded to support Amendment 16 but cannot support 118 as it refers to the resources available to the landowner. And we all know that land ownership is often used to bury resources to avoid taxation. Therefore, it would be very easy for an unscrupulous a landowner to beg a lack of resources to take them out of the obligations of the bill. Ariane Burgess' Amendment 232 ensures that the land referred to in this section must have their ownership registered, and often we hear of people not being able to contact their land, the owner of their land, the land they lease, and it's only right that that land ownership is transparent and therefore registered. Michael Matheson's Amendment 269 obliges Scottish ministers to issue guidance around the obligations in this section, and again, this improves the bill. Thank you.
Thank you. I now call Edward Mountain to speak to Amendment 16 and other amendments in the group. Mr Mountain.
Thank you, Presiding Officer. My amendments in this group are to do with proportionality and community engagement. Amendment 16 inserts the provision that ministers must ensure that community engagement obligations are proportionate relative to the size of the landholding, the number of communities involved and the size of those communities. This is based on evidence that we heard at stage 2 in the debate. Amendment 118 would define proportionality in relation to the resources available to the owner, the size of the holding and the number and size of communities in vicinity of the holding. The Cabinet Secretary has, in previous comments, alluded to the fact that land management plans are intended to be high level and will not propose an undue burden on landowners. These amendments seek to ground those reassurances in legislation, which I'm sure she'll be delighted to support. I have to say on the point that Rhoda Grant made on Amendment 118, I would encourage her to look on the bright side of life and not always look on the negative side, which is what she suggests, that it would all be about giving loopholes for landowners to involve getting in land management plans. Turning to Amendment 132, in the name of Ariane Burgess, I have no issues with declaring publicly who owns what. In fact, my party and I recognise and support this. However, what is being proposed must be proportionate and reasonable. To move this amendment now on the basis that the registrar is still trying to comply with the requirement to register all land ownership would be, frankly, unreasonable. Therefore, I cannot support this. Turning to Amendment 263 and 133 in the name of Rhoda Grant, Ms Grant will know that I'm a great fan of crofting, but it is just such a sadness that this government has failed, despite what they said they would do in 2016 to carry out crofting reform. In fact, the legislation they put for the Parliament at the moment is at best fiddling round the edges, Mr Fairley, and I'll take the intervention at that point.
Minister, briefly.
Would the member recognise that there is a crofting bill currently going through this Parliament as we speak?
Edward May.
Well, in your excitement of jumping to your feet, Mr Fairley, you didn't hear what I said, that I accept the the law that's going through at the moment is at best fiddling round the edges. Now, I would remind the Parliament in 2016, Mr Ewing said that he would bring forward a Crofting Act and that it would be perfect to replace the Crofting Acts that were there. The trouble is, of course, that that failed and disappeared, and they failed to grasp the nettle. And the government have failed to grasp the nettle with small holdings effectively so that they could be properly considered. All they've done is parked, in my mind, small holdings on the back burner, which is a failure of this government and the Minister. Michael Matheson, in moving Amendment 269, is getting the government, I believe, out of a pickle, which shows the inadequacies of this legislation. He's seeking to find what is required under community engagement, which was an issue that the committee brought up and the government failed to address at stage 2 and stage 3. I respect Mr Matheson's position on this, and as I'm sure he has drafted the amendment without the help of government, who is probably thankful of his intervention. I'm, however, concerned that this is allowing yet more legislation to be enforced by regulation, which I find difficult, where the best part of legislation should be on the face of the bill, Presiding Officer.
Thank you. I call Michael Matheson to speak to Amendment 269 and other amendments in the group. Mr Matheson.
Thank you, Deputy Presiding Officer. I don't consider this amendment as an attempt to get the government out of a pickle. I hope it's an amendment which helps to aid and provide clarity around the bill, because one of the key measures within the bill is the provision for land management plans in order to help to provide local communities and individuals who live next to large estates in particular the opportunity to engage with the landowner, and for the landowner to engage with those local communities around how they intend to manage and use the land in the years ahead. Key to that is developing the land management plans in a way which engages the local community and allows them the opportunity to influence that process and the outcome from the land management plan, which is why I think the community engagement provisions which are within the bill at the present moment are extremely important and helpful. I should add, though, that it is worth noting that some of our landowners actually do very good work in engaging with local communities directly at the present time, notwithstanding the provisions in this bill. And I know that from my own experience, when I spent some time with Patrick Cahoon at Luss Estate prior to the Stage 1 process, where there has been extensive engagement with the local community around how they go about managing their land. What this particular amendment will do is it will require ministers to consult on and also to make publicly available guidance in relation to the new community engagement regulations provided for within the bill. The details of the community engagement obligations will also be set out further with regulations, which clearly have to be consulted on by the government. However, I believe that with Amendment 269, it will help to ensure that there is also guidance to support understanding and the benefit understanding of how these community engagement obligations should be taken forward. And in that way, it benefits both the local community and the landowner in providing greater clarity.
Thank you. I call the Cabinet Secretary.
Firstly, I welcome Michael Matheson's Amendment 269, which will create that duty on ministers to consult on, issue and make publicly available guidance in relation to the new community engagement obligations. I said at stage 2 that I was happy for that to be made clear on the face of the bill, and I would urge members to support that amendment. Now, Edward Mountain has introduced 2 amendments to this group, which would force ministers to tailor community engagement obligations to the individual circumstances of each and every large landholding that's subject to the provisions in the bill. I think they would create that significant and unjustifiable resource and administrative burden on ministers, given that they would require an assessment of each and every large landholding. Now, it will be far better for ministers to develop proportionate rules following that appropriate consultation with the relevant stakeholders, because that will ensure that obligations address all types of landholding in Scotland in as consistent a way as possible. Yes, I'm happy
Edward
to
Mountain, briefly.
I do understand the merits of some of the arguments put forward by the Cabinet Secretary, but we heard in the committee at stage 1 that the costs of producing land management plans would probably be in the region of a minimum of about £10,000 and could for a large estate be considerably more than that. What I'm trying to do with these amendments, Cabinet Secretary, is to make sure that a small farmer, say with 1,000 hectares, hasn't got to spend £10,000, get in specialist people to take advice. And if that's not your aim, and you're not going to support my amendments, perhaps you'd be clear, perhaps the Cabinet Secretary would be clear, Presiding Officer, that that is indeed her aim, and that will be covered in regulation.
Cabinet Secretary.
Well, hopefully I was clear in terms of what I set out and what that would aim to do, because I absolutely appreciate the intent of Edward Mountain's amendments, but that's why I've said that it is important that we develop those proportionate rules following that appropriate consultation with relevant stakeholders, but that we do that in a way that ensures we are dealing with landholdings in a consistent way. So I want to provide that assurance. But as I say, I would urge members to vote against them. Yes, I'm happy to take an intervention.
The Cabinet Secretary reflect on the fact that my recollection of our committee at stage 2 is we heard that it cost around £5,000 or so for a land management plan, not £10,000 plus, and that many landowners were already doing the good work that's involved already in relation to land management plans. But notwithstanding that, Cabinet Secretary, do you agree that the fact that my amendment at stage 2 would increase the fine for not producing a land management plan was quite a sage thing to do if it cost as much as £10,000 to £15,000 in the first place?
All through the Chair. Cabinet Secretary.
Yes, I completely appreciate the important point that Bob Doris raises, and I think we'll return to some of these issues when we come to later groups in the debate over the course of the day. Now, in relation to Rhoda Grant's amendments 263 and 117, which introduce a duty on landowners to give consideration to reasonable requests made by community bodies or crofting community bodies for the landowner to apply to have land designated as a croft, I would ask members, of course I think Rhoda Grant touched on Amendment 113, that she may not be pressing that, so it's just to ask members not to support that because it does have a narrower scope than its counterpart 263, which we will be supporting. And lastly, just to turn to Ariane Burgess's amendments 116 and 132. Firstly, I just want to state I fully support the transparency of ownership. It is a vital part of land reform, and this amendment would seem to require all landholdings registered on the Sessions Register to be transferred to the Land Register. However, the information contained in the Sessions Register has been made more easily accessible. The Unlocking Sessions project taken forward by Registers of Scotland in recent years has really been a significant step in enhancing visibility and accessibility of the register, which is the oldest national public land register in the world. Though I appreciate the benefits of a completed land register and I fully support improving the transparency that Ariane Burgess is looking for, unfortunately there are a number of issues with the amendments. The way they're drafted places a legal duty on landowners to ensure their details are in the land register. However, responsibility for registration of those details in the land register rests with the keeper once an application for registration is made. So we cannot put a responsibility on landowners that is out of their control, given the responsibilities of the register sit with the keeper. Now, the process involved in moving to the land register also involves sometimes significant conveyancing, surveying and other legal costs, and none of that has been considered, and there hasn't been a business and regulatory impact assessment. Now, the cost to a range of landowners, including local authorities, charitable trusts and public bodies, could be significant, and I think it's not fair to impose those without proper consideration and consultation. Now, we also have to consider the impact on Registrars of Scotland who had no prior consultation before this amendment was lodged and aren't currently resourced to process the increase in registrations that this would generate. I would, however, like to point to the consultation and development that we will undertake on the content of the land management plans. We currently require that owners will have to include details of the land, including how ownership is structured, and I think there is scope for further details such as maps to be included. Now, land management plans are going to be publicly available and free to access online, thanks to amendments which we'll be considering in the next group from Bob Doris, which I intend to support. And we would consider, as part of that wider consultation on land management plan regulations, whether the power to impose the community engagement obligations or other available powers could be used to introduce further measures to address the aims of the amendments that the member has brought forward. So I would therefore ask Ariane Burgess not to move this amendment, and I would like to offer to discuss this point further to identify how we can work together on some of the issues that she's raised. Thank you.
Thank you. I call Ariane Burgess to wind up. Press to withdraw Amendment 116. Ms Burgess.
Thank you. I'm disappointed that the Cabinet Secretary cannot support my amendments, but I welcome the points that the Cabinet Secretary made around the consultation on land management plans being in development and the potential for that, including maps. I just want to underscore that if we are to move forward with modernisation of our taxation system to focus on wealth and wealth redistribution rather than income, we need to have an up-to-date public record of land ownership and valuation of the land. And I look forward to that being taken forward by the government as a matter of urgency.
Just to clarify, Ms Burgess, are you pressing Amendment 116?
I'm pressing.
Question is that Amendment 116 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Kenneth Gibson.
Thank you, Presiding Officer. According to this wonderful message, the digital platform could not be started. So therefore, I would have voted no.
Thank you, Mr Gibson. I'll make sure that is recorded. And the result of the vote on Amendment number 116 in the name of Ariane Burgess is yes 27, no 87. There were no abstentions. The amendment is therefore not agreed. I call Amendment 117 in the name of Rhoda Grant, already debated with Amendment 116. Rhoda Grant to move or not move?
Moved.
Question is that Amendment 117 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 117 in the name of Rhoda Grant is yes 86, no 27. There were no abstentions. The amendment is therefore agreed. I call Amendment 234 in the name of Mark Ruskell. Already debated with Amendment 232. Mark Ruskell, to move or not move?
Not moved.
That is not moved. I call Amendment 16 in the name of Edward Mountain. Already debated with Amendment 116. Edward Mountain, to move or not move? Question is that Amendment 16 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 16 in the name of Edward Mountain is yes 48, no 66. There were no abstentions. The amendment is therefore not agreed. I call Amendment 118 in the name of Edward Mountain. Already debated with Amendment 116. Edward Mountain, to move or not move?
Moved.
The question is that Amendment 118 be agreed to. Are we all agreed?
Yes.
Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 118 in the name of Edward Mountain is yes 28, no 86. There were no abstentions. The amendment is therefore not agreed. We come to Group 4, Land Management Plans. I call Amendment 235 in the name of Bob Doris. Group with amendments as shown in the groupings. I draw members' attention to the procedural notes on amendments in this group as set out in the groupings. Bob Doris to move Amendment 235 and speak to other amendments in the group. Mr Doris.
Thank you, Presiding Officer. And I'll move 235 just now in case I forget to do so later. Those who followed stage 2, I'm sure that was most people in this chamber, Presiding Officer, will be aware that I work with Community Land Scotland seeking to ensure that land management plans should be transparent, available and accessible in the one place. Having a single website on which all land management plans across Scotland will be located and updated in a timely manner. How the public know they've been complied with, they can access them and scrutinise them for themselves. The Scottish Government agreed and has therefore worked with me on Amendments 258, 235 and 276, which will make provision for this. Amendment 258 clarifies that the future regulations imposing the obligations to have a plan can make the necessary provision to require that the landowner submit it to another person so that it can be published on a single website. Amendments 235 and 276 will give ministers the ability to confer functions on any public authority, including themselves, and will allow for future regulations to require a body to establish such a website. It will mean that ministers can require that a public body should publish land management plans in a single place, and this can be the means by which landowners make the land management plans available. It would also allow for the setting of a reasonable fee, modest, for example, a small administrative fee to be paid by landowners whilst keeping those plans accessible free of charge to those who wish to look for them and search for them. My amendment set out that consultation must be carried out before these regulations are laid, and they must be laid under the affirmative procedure. My amendments 239, 260 and 262 replace and update my Stage 2 amendment requiring ministers to publish a statement setting out reasons when they lay regulations which exclude land from the obligations in the bill regarding land management plans. I laid a similar amendment at stage 2 and believe it is important for ministers to be transparent about the reasons for removing any land from its scope. Amendment 239 removes the drafting added by my stage 2 amendment. Amendments 260 and 262 add back in the requirement for a statement to be made following the standard drafting approach for statements of this kind. This requirement on ministers will make a statement will mean that to make a statement will apply if they exclude land from the land management plan obligations and additionally from obligations to consider community requests to lease land under section 44C. My amendments 256 and 257 clarify that community engagement obligations will be able to set requirements on landowners in relation to how they should comply with the obligations, including when there is a change of ownership. I felt, as did Community Land Scotland, that the previous wording could be interpreted that the landowner only may, as opposed to must, comply with obligations. This change is to make it clear that these regulations can include provisions, mandatory provisions that landowners must comply with, as well as allowing for flexibility where appropriate. I recognise that it could make sense to provide options and have flexibility, for example, allowing a new landowner to update a previous plan or to create a completely new one if their plans for the land differ significantly. I look forward to listening to the amendments from others in this group. Thank you, Presiding Officer.
Thank you, Mr Doris. I call Rhoda Grant to speak to Amendment 236 and other amendments in the group. Ms Grant.
Thank you, Presiding Officer. Amendments 236, 237, 243, 244 and 250 are largely tidying up amendments, moving the reference to consultation with tenants and crofters into the same subsection that deals with consultation with communities. Can I thank the Cabinet Secretary for her assistance with these amendments? The Cabinet Secretary's Amendment 130 not only preempts my Amendment 131, it also takes out a section that relates to an owner holding 2 or more holdings. My Amendment 131 makes it clear that where a landowner has 2 or more holdings totalling 500 hectares, they are obliged to have a land management plan for these holdings. I would ask members to vote against the Government Amendment 130, as cumulative land holdings should come under the obligations of this bill. It is now very common for people and organisations to be buying up multiple pieces of land which individually don't come under the obligations of this bill, but when added together make a substantial land holding. Often these are used to offset carbon emissions elsewhere. I agree with Edward Mountain's Amendment 22 in that it establishes a database of land management plans. Bob Doris's Amendment 258 is similar, so we would support both those amendments. Ariane Burgess's Amendment 119, I feel, is too onerous. Very little progress would be made in a year, and this will quickly become a paper exercise that in reality is not meaningful. Edward Mountain's Amendment 17 moves the review period from 5 years to 10 years. It seems reasonable given that change is slow on large land holdings. Any changes to the plan during these periods would also have to be consulted upon. Edward Mountain's Amendment 18 appears reasonable, but 120 undermines the purposes of the bill with the requirement that the requirement to have a land management plan needs to consider whether a landowner has the resources to develop one, and I won't rehash my concerns in this regard as stated before. Douglas Lumsden's amendments are largely to do with renewable energy and transmission, and frankly that's what the planning system is for. I have some sympathy with Amendment 254, which seeks to have communities consulted regarding energy developments. Scottish Labour tried to introduce a third-party right of appeal when the planning bill was going through Parliament, but this was voted down. And that is where these principles should have been resigned. But to put this provision in the bill gives communities input to one type of development only, and it further complicates planning law. That said, communities will be consulted on land management plans created under this legislation, which will include all developments on land, and that will give them a greater input than they currently have. Therefore, I believe Amendment 254 is unnecessary.
Thank you. And I call Ariane Burgess to speak to Amendment 119 and other amendments in the group. Ms Burgess.
Thank you. This bill has been before Parliament for more than 2 years. And over that time, we've spent many hours considering the implications of land management plans, how they can be made effective to address community needs, and what are reasonable expectations to place on land managers. And yet, despite all of those hours of discussion at Stage 1 and Stage 2, I remain deeply concerned that there is nothing in the bill that requires land management plans to be implemented by land managers. As it stands, large landowners will need to produce land management plans, and as part of that, they will need to engage with local communities and take their feedback into account. But there is nothing that requires the plans are put into practice. Now, I recognise that there are instances where plans made with the best of intentions cannot be carried out. Another period of bad weather, like Storm Amy earlier this year, could hamper tree planting efforts, or times when sudden economic shocks means that different priorities must come to the fore. And my Amendment 119 looks to strike a balance between a blanket requirement for plans to be implemented and the current absence of accountability in the bill. And it would require landowners to submit an annual progress report to the Land and Communities Commissioner. And this would provide a light touch oversight of how LMPs are being taken forward in practice. This is to provide transparency about how plans are progressing, and it would not require the Land and Communities Commissioner to follow up on reports. We must ensure that the measures in the bill are robust and that LMPs are not reduced to paperwork that languishes on a shelf or on a hard drive. I urge members to support Amendment 119. Turning to my other amendments in this group, they addressed an issue I raised at Stage 2 about asking large landowners to consider how their plans can contribute to nature recovery in Scotland. Members should by now know the dire statistics. Scotland is one of the most nature-depleted countries in Europe, and 1 in 9 species are at risk of extinction from Scotland. Provisions under Section 44B(3) currently requires that land management plans set out how the land will be managed to help meet Scotland's net zero targets and aid climate adaptation. But Scottish Greens believe the legislation needs to include an equal requirement to set out how plans will aid nature recovery efforts. And I propose 2 options for this. Amendment 123 would see the deletion of the words "or sustaining" from Section 44B(3), leaving a clear requirement for land management plans to set out how they will contribute to increasing biodiversity. Amendment 124 takes an alternative approach, requiring that plans set out their contribution to any biodiversity targets set under the Nature Conservation Scotland Act 2004. Members may be aware that the Natural Environment Bill currently before the Rural Affairs and Islands Committee will in due course set such biodiversity targets. Amendment 124 would ensure that there is a parity between the focus on climate targets and nature targets when it comes to how Scotland's largest land holdings are managed. And I give my thanks to Scottish Rewilding Alliance for their support with these amendments.
Thank you. I now call Mark Ruskell to speak to Amendment 238 and other amendments in the group. Mr Ruskell.
Presiding Officer, given that 238 was consequential to the amendments I was proposing in Group 1, I intend to not move 238 in this group. Thank you.
Thank you. I call Edward Mountain to speak to Amendment 17 and other amendments in the group. Mr Mountain.
Thank you, Presiding Officer, and I have 16 amendments in this group, so I'll be as quickly as can. My amendments in this group fall under 4 key themes: the development of land management plans, the contents of those plans, proportionality and costings of community engagement, and the development of an online database for plans. Amendment 17 changes the management plan review period from 5 to 10 years. I'm surprised the Government haven't listened to the clear Stage 2 evidence that we heard that 5 years for a management plan is incompatible with good land management and also achieving what is set out in them. Land management plans tend to last for long periods of time. 20 years is not unheard of, and forestry plans last obviously for much longer than that. Therefore, to say you need to review a plan after 5 years is, to mind, unhelpful, which is why my amendment, taking it to 10 years, is far more sensible and based on the experience I have within the industry and as a farmer of over 40 years' practice. Amendment 18 imposes an obligation on all parties to work reasonably regarding the development and changes to the management plan. I know this amendment is not supported by SLE, and it's good that I don't always have to toe their line. I think what we accept is that there are people that might not act reasonably, and that could be landowners or with a community. And their behaviour both needs to be curbed to ensure the new legislation is not hindered, but works as intended. I expect the government will feel this is not enforceable, but in my view, inserting a reasonable requirement to work together would give the Land and Communities Commissioner sufficient stick to bring either side back to the fold. Turning to management plans, the contents, Amendment 19 removes the reference to the Scottish Outdoor Access Code, so that landowners will not have to detail within their management plan how they intend to comply with the Scottish Outdoor Access Code. It's not required, it's law. Amendment 122 is an alternative amendment to Amendment 19, which improves the subsection by clarifying that the requirement to include details within the management plan of how the landowner intends to comply with the Scottish Outdoor Access Code insofar as it implies duties on the landowner. So there is a choice there for the government. Amendment 20 removes the requirement for landowners to detail with the plan how they will comply with the code of practice on deer management. And Amendment 245 is an alternative amendment to Amendment 20, which requires instead to disclose the extent that landowners intend to comply with the code of deer practice. Amendment 21 removes the requirement to detail within the plan how landowners will manage the land in a way which contributes to increasing sustainability and biodiversity. Amendment 125 is a wording change. Rather than detailing how a landowner will comply with the local plan, they must show to the extent to which they will comply. Amendment 246 is similar. Landowners must detail the extent in which they intend to manage the land in a way that contributes towards the achievement of the net zero emissions targets that are set out by the government. Amendment 248 clarifies the achievement of net zero targets by the ministers and that landowners' efforts towards these targets are just a contribution. As the targets are an obligation imposed on ministers rather than landowners, this is an important change to the bill to make it legally viable. Amendment 242 ensures that the landowner's obligation to include information about their potential plans to sell the land is only required insofar as such as information is not commercially sensitive. The Cabinet Secretary stated at Stage 2 that management plans would not be expected to contain commercially sensitive information. So this amendment reflects that intent. Turning to Amendment 120, this introduces a subsection which mandates the engagement regarding to land management plans must be reasonable and proportionate to the resources available to the landowner and the scale and relevant to the communities and size of the holding. Amendment 128 ensures the costs for producing land management plans are proportionate as well. My experience tells me, and I heard what Mr Doris said earlier, that £10,000 will probably be the minimum that a complicated land management plan will cost, and considerably more, perhaps up to 40 or 50,000 for a more complicated one. There are members in this chamber who will maybe question those figures, but in the period of 1998 to 2003, trying to resolve woodland grant schemes, I know that it cost my client working on his behalf £45,000 worth of my time. And that wasn't for a management time, that was a woodland grant scheme, and it was fairly complicated. On the online database, Amendment 22 obliges the Minister to establish an online database for the publication of land management plans. Amendment 308 inserts a function for the Land and Communities Commissioner for the maintenance of that online database that is established by Amendment 22. Amendment 40 is to help the government and is a technical amendment consequential to Amendment 22, which allows the ministers to modify this chapter if required. Having an online database for the publication of land management plans is simple and straightforward. I know that the NFUS don't like this amendment, and even though I'm a farmer, I don't have to agree with everything that they say. When it comes to this, I think we need to move with the times, and nearly everything that we do can be found online, including the NFUS and their policy strategy, which is why I'm happy to see this there. Have I time to turn to the other amendments in the group, Presiding Officer?
Very briefly.
Okay. Probably suffice to say, if I can, if it's that brief, I don't support any of them, except for Douglas Lumsden's, which I find entirely sensible and reasonable. Thank you.
Thank you. I now call Tim Eagle to speak to Amendment 121 and other amendments in the group.
Thank you, Presiding Officer. And before I debate my amendments at stage 3, can I just draw members' attention to my register of interests? I do run a small farm in Murray, and I have a couple of short, limited duration tenancies. The bill currently requires landowners to include in their land management plans details about their long-term vision and objectives for managing the land, including plans for its potential sale. My Amendment 241 removes the need to include any information about the potential sale of land. I don't personally see how it can be right or reasonable for a landowner to have to speculate in plans about future sales, which most likely they won't be ready to discuss. If the bill does go forward as drafted, there will already be the right for communities to register interest in land. Therefore, forcing landowners to highlight potential sales is not necessary within the context of the management plans. The bill also currently requires the land management plan to contain information about how the owner is managing the land in a way that contributes towards achieving net zero emissions targets set by Section A1 of the Climate Change Scotland Act 2009. Now, there is no doubt that protecting our environment is important, although I accept we have differences of opinion on how that might be best achieved. However, Section A1 of the 2009 Act puts requirements on Scottish ministers to set net zero emissions targets. It does not directly put those targets on landowners. Farmers and landowners are already working actively to cut emissions and increase their efficiencies, with a 13% reduction already since 1990. With them ready to go further, I do not support the administrative burden that this part would impose. As one farmer has warned publicly, we must avoid elevating environmental concern to the Premier League whilst relegating food production to the second division. If we maintain such attitudes, the reality will be empty shelves. I fear this is a step too far. Now, my Amendment 127 seeks to simplify the land management plans, and this is something I'm quite passionate about, for hill sheep farmers. The land management plan, in my view, imposes numerous administrative, time-consuming and potentially costly burdens on farmers. This includes engaging with communities, explanation of legislative adherence and substantial details about ownerships and future plans for the land. The financial memorandum published with the bill suggested that a landowner could be faced with a £15,000 bill for just drafting their land management plan. Further costs have been predicted, such as up to £3,600 for mapping their holding, for example. Hill farming, in my mind, is an industry which has a history of being the backbone of livestock production in Scotland. However, it is a fragile industry and dependent on support. Through my Amendment 127, I have tried to find a balance between greater transparency that the bill tries to establish through the land management plans and easing the burden on this particular category of farmer. Happy to, Mr Mountain.
Edward Main.
I thank the member for giving way. I just would wonder, Presiding Officer, if the member would accept my abject apologies that I failed to talk about his very sensible amendments in this group, and whether he would accept that I would, of course, be supporting them because they make a lot of sense. Thank you, Presiding Officer.
Tim Eagle.
Delighted to hear that, Presiding Officer. So I thought you were going to tell me how much you admire sheep, like myself. But my Amendment 127 tries to get that balance between greater transparency and easing the burden on this very particular category of farmers. And this is quite unique, but there will be a few cases of hill farms, particularly in the west of Scotland, that are over the 1,000 hectare limit that is likely to be imposed through this bill. I urge members to recognise the effect plans will have on those purely upland sheep farms and back this amendment. And my Amendments 127A and 121 are drafting amendments. Thank you, Presiding Officer.
Thank you. Call Douglas Lumsden to speak to Amendment 240 and other amendments in the group.
Thank you, Presiding Officer. And there is a theme to most of my amendments I'm bringing to stage 3. I'm nothing if not predictable, Presiding Officer. The SNP government talk about community involvement and giving communities a say, but when it comes to energy infrastructure, communities are feeling ignored, and communities right across Scotland are angry with the scale of monster pylons, battery storage and substations that are appearing across much of rural Scotland. And it's just not the look of these monster pylons that people are angry about. People are seeing their property prices slashed. They're concerned about the loss of countryside. They're concerned about impact on health. They have safety concerns. They're concerned about the impact on tourism. And they're concerned about the destruction of farmland. Amendment 240 requires high-quality agricultural land to be identified in a land management plan, and I don't think there's anything contentious about that. Amendment 249 just sets out that high-quality agricultural land identified is not used for major energy infrastructure. We often hear about energy security, but what about food security? We should not destroy our farmland. We must protect it for generations to come. Amendment 251 is just looking for some transparency. If land is going to be used for pylons, then this should be in the land management plan that the local community can have a say on. And if a landowner does intend to enter an agreement to allow construction of pylons, then Amendment 253 obligates the landowner to take the cumulative impact of energy infrastructure into account. Communities are concerned that it's not just pylons that are coming to the area, it's other infrastructure that will come on the back of pylons, substations, battery storage, hydrogen plants, example. And it's the cumulative impact that's so devastating on our communities. I'll give way to
Jackie Dunbar briefly.
Thank you, Presiding Officer, and I thank the member for taking the intervention. It's just a quick question. You've been discussing pylons. Can you maybe tell the Chamber what size of pylons do you consider to be unacceptable? Because obviously some are more acceptable than others. So I genuinely would be interested in the answer.
I don't have a view on the pylons. Always through the chair, Ms Dunbar. Douglas Lumsden.
Well, I'm disappointed, Presiding Officer, that you don't have a view on that. But I think when you look at the applications coming forward by SSEN, the pylons are a much greater size, I think up to 50 metres, if I'm not mistaken. So it's much larger than the ones that are actually in place just now, and that's what people have got concerns about. People have got concerns about the sag height of the cables. Operating farm equipment under that is also a big concern. Amendment 254 means that a landowner would have to set out what mitigations have been incorporated if pylons are planned for an area, and these mitigations should be done with an independent expert with knowledge of pylon construction. And, Presiding Officer, lastly, Amendment 255 just sets out that if pylons are proposed, just to set out why they couldn't be undergrounded instead. So if the Government are serious about transparency and giving communities a greater say when it comes to monster pylons, and I'm sure they will support these amendments. Thank you, Presiding Officer.
Thank you. I now call on the Cabinet Secretary to speak to Amendment 126. Other amendments in the group. Cabinet Secretary.
Thank you, Presiding Officer. My Amendment 126 seeks to overturn an amendment from Rhoda Grant at Stage 2, which required ministers to appoint an independent person to fulfil the community engagement obligations with regards to the Crofting estate owned by Scottish ministers. I just want to be clear, first of all, that I do want us to be able to set a leading example for how landowners should be engaging with people who live and work on their landholdings. And I don't think it's appropriate that when every other owner of a large landholding is required to undertake that engagement, that Scottish ministers would then be hiving off that duty to someone else, and it would leave crofters on these estates with worse rights in terms of engagement with the landowner than others. Additionally, it's unclear who the independent person should be, how they would be appointed, or how they could fulfil the duties when they're not representing the landowner. I think it would be confusing and could lead to significant and unnecessary costs for the public sector, which is why I would ask Rhoda Grant not to press it. But yes, I'm happy to take an intervention.
Just a quick intervention in that. I mean, this is for all time coming, and I'm not casting aspersions on this government, but what happens if there is a community on land owned by the Scottish Government and they feel that their rights under this legislation are not being attended to, because the appeal is to the Scottish Government to do something about that, and the Scottish Government cannot police itself?
Cabinet Secretary.
You're absolutely right, and I wouldn't expect that to happen either, but that's exactly what the position of the Land and Communities Commissioner is for, which is independent of the Government, and I would expect them to treat us exactly the same way as they would treating other bodies and landowners who are subject to the measures that we're introducing in the bill. Now, during Stage 2, Rhoda Grant also passed an amendment to cover what was to happen if a landowner required land management plans, but the land that led to this requirement was spread over multiple holdings, and it suggests the Commissioner should direct landowners in this case I think it was meant to support other amendments that did not pass at stage 2, which looked to remove requirements for land holdings counting towards the threshold to be contiguous with one another. Because the bill does require land to be contiguous to count towards the 1,000 hectare threshold, this amendment isn't necessary. Importantly, it does also have a number of drafting issues because it doesn't specify which commissioner is to direct landowners, and the definitions of land are inconsistent with the rest of the bill, meaning they won't cover the holdings that they should do. It also makes no provision for enforcement of the Commissioner's direction and therefore brings uncertainty and confusion into the bill. So that's why I'm intending to undo this amendment through my Amendment 130, and we'd urge members to support that. Rhoda Grant's Amendment 131 suffers from similar flaws to the amendments she passed at stage 2 that I've just described, and again would urge members to also reject that amendment. Now, when turning to Bob Doris's amendments 235, 258 and 276, which allow further provision in connection with community engagement obligations to be made in future and will enable ministers to legislate for a central accessible portal for all land management plans. The detail of that would be set out in regulations subject to the affirmative procedure following appropriate consultation. Now, I think we would all agree that it's important for LMPs to be easily accessible and maximising our transparency objectives. I completely understand the intent of Edward Mountain's amendments in relation to this too, but unfortunately I can't support those because they would require that online portal to be delivered by ministers directly and maintained by the Land and Communities Commissioner. Now, that's not necessarily the most appropriate or cost-effective way of hosting the LMPs. Yes, I'm happy to give way.
Edward Mountain.
And I thank the Cabinet Secretary for giving way. I think you'll find my amendment gave the option for you to amend this chapter should it so require. But the principle is that we're looking for an online database of management plans. So you could accept my amendment if you were being generous and then amend it like you're doing with so much other parts of the bill by regulation afterwards.
Again, through the Chair, Mr Mountain.
Of course.
Cabinet Secretary.
Well, what I would say is that, again, that's why I'm supporting Bob Doris's amendments in relation to this, because they actually allow more of that flexibility, which is why I'm unable to support Edward Mountain's amendments. I support Rhoda Grant's amendments 236, 237, 243, 244 and 250. Following discussions at stage 2, these make it clear where the development of a land management plan will require specific engagement with tenants, including crofters and small landholders, and would urge all members to support these amendments. I also support Bob Doris's amendments 239, 262 and 260 because they relate to the statement that ministers need to make if excluding any land from the obligations around land management plans. In some rare cases, it might be appropriate for land not to be subject to these obligations, and I think in those situations it's quite right for ministers to set out the rationale for that decision. And they improve similar amendments that passed at stage 2, and I encourage members to support them. Now, turning to amendments 120 and 128 from Edward Mountain, they're concerned with making LMP obligations proportionate to the landholding size, the makeup of nearby communities and the resources available to the landowner. Once again, as I've highlighted in the previous group, the regulation-making powers for land management plans are the appropriate place to consider these issues, and that means that they can then be considered in the round. And I think when we're designing these regulations, it is essential that we consider all these issues, but the amendments are too prescriptive and could give any unscrupulous landowners too much scope to try and avoid meaningful engagement just by asserting that they consider it to be disproportionate. Now, amendments 121, 127 and 127A from Tim Eagle seek to introduce different requirements for land holdings which are mainly used for sheep farming. I don't think it's appropriate that we distinguish large landowners by land use on the face of the bill, and additionally it's unclear who would make that judgment call about land use and how that decision could be challenged, which is why I'm unable to support that amendment today. Other amendments in the group 119 from Ariane Burgess would require all landowners to submit an annual report on their land management plans to the Land and Communities Commissioner. Now, an annual report is a significant undertaking and the impact on landowners hasn't properly been considered and could be substantial. And then we also have to think about the burden that that could then put on the Land and Communities Commissioner. I completely understand the intent. Landowners should be updating on how they've progressed against the plans they've set out, but that's something that we can cover appropriately in regulations. So, for example, reviews of the LMP required every 5 years would be a suitable time to set out how progress has occurred since the previous review or the previous plan. So I would ask Ariane Burgess not to move her amendment in relation to this. Now, turning to Amendment 17 from Edward Mountain, it works against the intent of the bill by undercutting community engagement obligations and would require LMPs to only be produced and engaged on every 10 years instead of the current 5, and would ask members not to support that. Amendment 18 should also be opposed. It imposes obligations on communities relating to land management plans and seems to take responsibility away from landowners. I've been clear throughout that landowners are responsible for engaging communities and producing LMPs. They're the ones who own the land and should take responsibility for the plans, and I don't think it's reasonable to try and shift this responsibility to communities, and would urge members to oppose it. And with that, though, I would encourage members to support 256 and 257 from Bob Doris. They further clarify amendments that we supported at stage 2 regarding the type of provision that could be made about compliance with community engagement obligations, and that includes in circumstances in which the ownership of land is transferred. Now, I turn now to the amendments in the group which relate to the content of land management plans. Tim Eagle's 241 seeks to remove the requirement for regulations to require landowners to include information about the potential sale of a land holding from its LMP. Edward Mountain is also looking to water down this requirement through Amendment 242, which would require that information about a potential sale need only be required if the information is not commercially sensitive. But both of these amendments completely miss the point of the engagement requirements. Communities close to large landholdings should be consulted on and aware of significant changes, such as the sale of land that they live and work on, and that's why I would ask members to oppose the amendments. I'm happy to take the intervention.
Edward Mountain.
And I thank the Cabinet Secretary for giving way. I mean, I'm actually, Presiding Officer, quite surprised that the Cabinet Secretary doesn't accept the words commercially sensitive. When it came to buying Glen Prosen, for example, none of the information was allowed to be made available to the public because it was considered to be commercially sensitive. So it appears that what is good for the government, Presiding Officer, is not good for a landowner, and I wonder if the Cabinet Secretary could respond to that, Presiding Officer.
Cabinet Secretary.
I think I've been clear through the evidence that I've provided multiple times at the committee in relation to these issues that, of course, we wouldn't expect that information to be published. And again, it's simply not the case, and I would disagree with the assertion that Edward Mountain has made in relation to that. Now, on the nature and climate provisions within this grouping, I think Edward Mountain and Tim Eagle appear to be working together to remove or reduce the effectiveness of some of the provisions in the section 44B, which sets out some of the detail which will be required to be set out in LMPs. 21 from Edward Mountain would delete any reference to how landowners are increasing or sustaining biodiversity, and 247 by Tim Eagle would take the same approach to remove any requirement for landowners to set out how they're managing land in a way consistent with net zero targets. So I recommend that these be opposed, and Edward Mountain's amendments 246 and 248 should also be opposed, as these again look to water down the nature provisions in the bill. But that's also why I then support Ariane Burgess's amendment 123. However, I can't support Ariane Burgess's other amendment 124 because it contains references to provisions in the Natural Environment Bill, which is still currently under consideration and subject to changes, as well as a final vote by Parliament. So I think this is something that could be instead picked up when we're consulting on the detailed requirements of the land management plan content. There are a number of other amendments in relation that Edward Mountain has brought forward, amendments 19, 122, 20, 245 and 125. All would weaken the measures in the bill and make it easier for owners of large landholdings to do less to fulfil their duties, and I would urge members to oppose them. Now, turning lastly to the amendments that have been brought forward by Douglas Lumsden. Now, firstly, he's brought forward a number of amendments relating to electricity infrastructure across this group, Group 6 and Group 11. Firstly, this is a matter of interest within my constituency, so I want to make clear that I appear before the Chamber today in my capacity as a Minister of the Scottish Government. The position I'm presenting reflects the collective view of the Scottish Government and concerns a matter of law and policy for which I have ministerial responsibility. Separately, and in line with the Scottish Ministerial Code, I've made my views and those of my constituents known to the responsible minister in the appropriate way. The issue under discussion today is distinct from that constituency interest, and my contributions today should therefore be understood as reflecting the Government's position and not a personal or constituency-specific stance. I'm not going to discuss each of these many amendments in detail because they all have the same fundamental issues. Land management plans are about transparency and supporting engagement with communities, and they're not the right place to try and address the issues that are covered by other legislative and policy frameworks, such as the National Planning Framework and consents processes. Now, a number of the issues that Douglas Lumsden raises connected to energy infrastructure are also reserved to the UK Government. So while I appreciate the issues that Douglas Lumsden is raising, this isn't the right vehicle to fix them, which is why I cannot support amendments 240, 249, 251, 253, 254 and 255.
Thank you. And I call Bob Doris to wind up and press or withdraw amendment 235.
Thank you very much, Presiding Officer. I'll just make some very brief observations. First of all, I welcome the Scottish Government supporting the amendments in my name. Can I reflect that Anna Burgess's Amendment 1, 2, 3 on land management plans to increase as opposed to sustaining biodiversity by managing or intend to manage land in such a way? I've been contacted with many constituents who are keen to see me support that particular amendment. I'm pleased that you've won that argument with the Scottish Government, and that hopefully will now pass today. I've also spoken to the Rewilding Alliance about that. Also, Mr Mountain can actually thank Mr Mountain for the efforts he's put in here at stage 3, and for maybe clarifying a wee bit more when he was talking about how much land management plans could potentially cost. He mentioned particularly complex ones, but it gives that a light and shade, I think, to those discussions that we had at stage 2, and I do welcome that. But also point out that he was very keen to see Mr Mountain is very keen to see land management plans extend for a 10-year period. Of course, there's nothing to stop a landowner having a land management plan for 10 years and reviewing and updating it after 5, which I think would very much be good practice and within the provisions within this bill. Yeah, of course.
Edward Mountain.
Thank you, and I thank the member for giving way. Of course, a land management plan for 10 years for a farmer actually won't mean anything. Land management plans for farmers tend to be much longer term than that. You know, 10 years investment in the machinery and the livestock, you're not investing that for 10 years. You're probably investing that for 20 years. So my question to the member, presiding officer, is does he not believe that 5 years is a blink in the eye when it comes to management of land and livestock and land holdings, and 10 years is more reasonable?
Bob Doris.
I thank Mr Mountain for the considered intervention. What I would say is this bill enables any landowner to do a land management plan for as long as they like, 15 years, 20 years, 30 years, Mr Mountain. I think any business involved in farming and agriculture that didn't review their business at least once every 5 years would be doing something remiss. So I think what Mr Mountain is looking for is already contained within this legislation. Very quickly, in relation to Mr Eagle's Amendment 241 about land management plans removing information, including its potential sale, and a linked amendment from Mr Mountain, I actually think that we're not asking for there to be an asking price for a sale of any potential land sale that a business is thinking of, Mr Eagle, but I think it's reasonable if a business is looking at options for how they're going to manage that land in the years ahead, that if disposing of that land is one of those potential options, the community really should be aware of it. I think that's a reasonable position to hold. Also on 247, and this is the last point I'll make, presiding officer, Mr Eagle spoke about removing regulatory requirements for land management plans to specify how they will contribute to achieve the net zero emissions targets. Mr Eagle, let me tell you, we all have our part to play.
Always through the chair, please.
Presiding officer, I think it's important that Mr Eagle knows that we all have our part to play. Every individual, every family, every community and every business for meeting these net zero targets, and that's incredibly important, and not to have it reflected in land management plans seems remiss to me, so I wouldn't be able to support that. My final comment is Mr Mountain, when he was challenging business earlier on, which is pertinent to this Group 4 of amendments, because Mr Mountain did not propose amendments at stage 2 to test the water with government, and therefore couldn't work with government ahead of stage 3 to produce something that could have been delivered. And I think that's an issue that Mr Mountain may want to consider in the future. Thank you, presiding officer.
Thank you. Point of order, Edward Mountain.
I just would like to amend the record, if I may, presiding officer, to say that I did work with the government, and I specifically met, as I'm sure the Cabinet Secretary will acknowledge, presiding officer, with her to discuss amendments where I think that ground would be met. I can actually give the date and those to the chamber if it's useful.
Thank you, Mr Mountain. That is not a point of order. We will continue with our business. Can I just confirm, Mr Doris, that you are pressing Amendment 235?
Yes.
Thank you very much. The question is that Amendment 235 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 235 in the name of Bob Doris is yes 88, no 26. There were no abstentions. The amendment is therefore agreed. I call amendment 236 in the name of Rhoda Grant, already debated, with amendment 235. Rhoda Grant, to move or not move?
Moved.
Thank you. The question is that amendment 236 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Co-Cab Stewart for a point of order.
Thank you, Presiding Officer. My app didn't work in time. I would have voted yes.
Thank you, Ms Stewart. We'll ensure that's recorded. The result of the vote on amendment number 236 in the name of Rhoda Grant is yes 88, no 27. There were no abstentions. The amendment is therefore agreed. I call amendment 237 in the name of Rhoda Grant, already debated, with amendment 235. Rhoda Grant, to move or not move?
Moved.
The question is that amendment 237 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 237 in the name of Rhoda Grant is yes 87, no 27. There were no abstentions. The amendment is therefore agreed. I call amendment 119 in the name of Ariane Burgess, already debated with amendment 235. Ariane Burgess, to move or not move?
Moved.
Thank you. The question is that amendment 119 be agreed to. Are we all agreed?
No.
The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 119 in the name of Ariane Burgess is yes 7, no 108. There were no abstentions. The amendment is therefore not agreed. I call amendment 238 in the name of Mark Ruskell, already debated with amendment 235. Mark Ruskell, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 17 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 17 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 17 in the name of Edward Mountain is yes 41, no 71. There were no abstentions. The amendment is therefore not agreed. I call amendment 18 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 18 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Richard Lockhead for a point of order.
That wasn't working. I'd have voted no.
Thank you, Mr Lockhead. We'll ensure that's recorded. I call Beatrice Wishart for a point of order.
Thanks, Presiding Officer. I don't think my app worked. I wonder if you could clarify if my vote was counted.
Your vote was not recorded, Ms Wishart.
I would have voted no.
We will ensure that that is recorded. The result of the vote on amendment number 18 in the name of Edward Mountain is yes 27, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 239 in the name of Bob Doris, already debated with amendment 235. Bob Doris, to move or not move?
Move, Presiding Officer.
Thank you. The question is that amendment 239 be agreed to. Are we all agreed?
Yes.
The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 239 in the name of Bob Doris is yes 68, no 42. There were no abstentions. The amendment is therefore agreed. I call amendment 120 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 120 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Sharon Dowie for a point of order.
I would have voted yes.
Thank you, Ms Dowie. We'll ensure that's recorded. The result of the vote on amendment number 120 in the name of Edward Mountain is yes 26, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 121 in the name of Tim Eagle, already debated with amendment 235. Tim Eagle, to move or not move?
Moved.
Thank you, Mr Eagle. The question is that amendment 121 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. Point of order, Emma Harper.
It looks like my app didn't connect for that one. I would have voted no.
Thank you, Ms Harper. We'll ensure that's recorded. The result of the vote on amendment number 121 in the name of Tim Eagle is yes 26, no 87. There were no abstentions. The amendment is therefore not agreed. I call amendment 240 in the name of Douglas Lumsden, already debated with amendment 235. Douglas Lumsden, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 240 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 240 in the name of Douglas Lumsden is yes 25, no 88. There were no abstentions. The amendment is therefore not agreed. I call amendment 241 in the name of Tim Eagle, already debated with amendment 235. And I remind members that if amendment 241 is agreed to, I cannot call amendment 242 due to a preemption. Tim Eagle, to move or not move?
Moved.
Thank you. The question is that amendment 241 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 241 in the name of Tim Eagle is yes 25, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 242 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 242 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 242 in the name of Edward Mountain is yes 26, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 243 in the name of Rhoda Grant, already debated with amendment 235. Rhoda Grant, to move or not move?
Moved.
Thank you. The question is that amendment 243 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 243 in the name of Rhoda Grant is yes 87, no 26. There were no abstentions. The amendment is therefore agreed. I call amendment 244 in the name of Rhoda Grant, already debated with amendment 235. Rhoda Grant, to move or not move?
Move.
Thank you. And the question is that amendment 244 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 244 in the name of Rhoda Grant is yes 85, no 26. There were no abstentions. The amendment is therefore agreed. I call amendment 19 in the name of Edward Mountain, already debated with amendment 235. And I remind members that if amendment 19 is agreed to, I cannot call amendment 122 due to a preemption. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. And the question is that amendment 19 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 19 in the name of Edward Mountain is yes 27, no 86. There were no abstentions. The amendment is therefore not agreed. I call Amendment 122 in the name of Edward Mountain, already debated, with Amendment 235. Edward Mountain, to move or not move?
Moved.
Thank you. The question is that Amendment 122 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 122 in the name of Edward Mountain is yes 26, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 20 in the name of Edward Mountain, already debated, with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 20 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 20 in the name of Edward Mountain is yes 27, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 245 in the name of Edward Mountain, already debated, with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 245 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 245 in the name of Edward Mountain is yes 27, no 84. There were no abstentions. The amendment is therefore not agreed. I call amendment 246 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 246 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 246 in the name of Edward Mountain is yes 27, no 88. There were no abstentions. The amendment is therefore not agreed. I call amendment 247 in the name of Tim Eagle, already debated with amendment 235, and I remind members that if amendment 247 is agreed to, I cannot call amendment 248 due to a preemption. Tim Eagle, to move or not move?
Moved.
Thank you. The question is that amendment 247 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 247 in the name of Tim Eagle is yes 27, no 87. There were no abstentions. The amendment is therefore not agreed. I call amendment 248 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 248 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 248 in the name of Edward Mountain is yes 27, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 21 in the name of Edward Mountain, already debated with amendment 235, And I remind members that if Amendment 21 is agreed to, I cannot call Amendment 123 due to a preemption. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that Amendment 21 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 21 in the name of Edward Mountain is yes 27, no 87. There were no abstentions. The amendment is therefore not agreed. I call Amendment 123 in the name of Ariane Burgess, already debated with Amendment 235. Ariane Burgess, to move or not move?
Moved.
Thank you. The question is that Amendment 123 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Richard Leonard for a point of order.
I was disconnected again. I would have voted yes.
Thank you, Mr Leonard. We'll ensure that's recorded. The result of the vote on amendment number 123 in the name of Ariane Burgess is yes 81, no 32. There were no abstentions. The amendment is therefore agreed. I call amendment 124 in the name of Ariane Burgess, already debated with amendment 235. Ariane Burgess, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 249 in the name of Douglas Lumsden, already debated with amendment 235. Douglas Lumsden, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 125 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved.
Thank you. The question is that amendment 125 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 125 in the name of Edward Mountain is yes 27, no 87. There were no abstentions. The amendment is therefore not agreed. I call amendment 250 in the name of Rhoda Grant, already debated with amendment 235. Rhoda Grant, to move or not move?
Moved.
Thank you. The question is that amendment 250 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 250 in the name of Rhoda Grant is yes 86, no 26. There were no abstentions. The amendment is therefore agreed. I call amendment 251 in the name of Douglas Lumsden, already debated with amendment 235. Douglas Lumsden, to move or not move?
Moved.
Thank you. The question is that amendment 251 be agreed to. Are we all agreed? The Parliament is not agreed. There will be division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 251 in the name of Douglas Lumsden is yes 41, no 71. There were no abstentions. The amendment is therefore not agreed. And we move to Group 5, obligations relating to land owned by community bodies. And I call amendment 252 in the name of Brian Whittle, grouped with amendments 259, 277 and 366. Brian Whittle to move amendment 252 and speak to all amendments in the group.
Thank you very much, Presiding Officer. In speaking to these amendments, I return to the question which I initially asked when initial consultation was launched, and that is, what problem is it we're trying to solve here? And throughout the passage of this bill, its supporters have repeatedly argued that large-scale land ownership is inherently harmful and that smaller community-based land ownership is inherently positive. These broad-brush positions seem to rely as much, if not more, on anecdote and ideology as evidence. And I do not doubt there are individual examples of poor behaviour by large landowners and exemplary outcomes among community-based ones. But equally many, in fact, I would say that the vast majority of landowners in Scotland, regardless of size, are good stewards of the land. Some time ago, during Mercedes v Alba's members' debate on her own proposal for land reform, I argued that if we are serious about land reform that makes a positive difference, we should be more concerned with how the land is managed than who actually owns the land and how much of it. And my position in that has not changed. And that brings me to my amendments, 3 of which are intended to address an apparent disparity in the use of land management plans between community-based organisations and other forms of landowner, whereby community organisations are not held to the same standard in the use of land management plans. Amendment 277 would require community bodies to produce land management plans in the same way as any other landowner whose holding meets the 50-hectare lotting threshold. It seems entirely reasonable to me that we should expect any large landowner, regardless of their structure, to be held to the same standard on land management. Amendment 259 would ensure that should a land holding with a land management plan already in place be purchased by a community group, the community group inherits that land management plan and should continue to deliver it until their own one is developed. Recognising that community bodies may require some time to develop practical land management plans, Amendment 366 provides a 5-year grace period from royal assent before land management plans are required for community-based land holdings. In addition, I am proposing Amendment 252, which is intended to address the issue of succession planning within community bodies. The nature of community bodies means that membership and leadership of that organisation can change frequently. Members come and go, priorities of communities change, and so on. In that situation, I believe it is important that the group have considered the implications of this and how their land holding is managed and ensure some level of continuity. I previously raised concern about how we ensure community groups have the tools and structures in place to be effective long-term owners of land. Unfortunately, those concerns were dismissed at the time. I am and remain a supporter of the principles of community owning land. However, I am acutely aware that land management is a long-term, even multi-generational task. Most members in this chamber will know of community organisations with good intentions who have failed following the departure of key members due to a lack of succession planning or other management failings. I believe it is important we take steps in this bill to address this risk. If, as some have asserted, accountability is the key element of this bill, then it is only right that every owner of land above the set threshold is required to meet the same standard of accountability. While I am aware that there are those who believe community ownership automatically bestows some greater moral authority that allows them a greater level of trust, I don't think that's the sound basis for legislation, hence these amendments. In short, these amendments seek to ensure that community-based owners of land are held to the same standard as others in their management of the land and manage the risks to that management in event of instability within the organisation, both of which I believe are entirely reasonable measures to take, and I move the amendments in my name. Presiding Officer.
Thank you. I call Rhoda Grant.
Presiding Officer, I don't have amendments in this section, but I just wanted to make a few comments because these amendments seek to hold community bodies to a higher standard than private landowners. If the policy intent for this amendment is to ensure continuity of land management plans, and so that national policy objectives for nature and net zero are met, this amendment would apply to any landowner or lots under these provisions, but they do not. These amendments show clearly that the Conservatives have no truck with community land ownership of land, which is already democratic and operates in the best interests of the community. Community groups.
Grateful for Rhoda Grant for giving way.
Brian Whittle.
Can I just correct what Rhoda Grant has just said there? My amendments are there to hold all land ownership to the same standard. No, not holding anybody else above anybody else. It's the same standard.
Rhoda Grant.
Community groups already hold themselves to a higher standard than private lords because they're working for the benefit of their communities rather than their own personal interests. They're democratically elected by their communities, and therefore I would urge members to vote against these amendments.
I call Edward Mountain.
Thank you very much, Presiding Officer, and I rise to speak in support of Brian Whittle's amendments, which I believe are entirely sensible and try and help community bodies work out what their organisational and successional planning is in relating to that plan. Also, it makes clear Amendment 259 is that once a community body has purchased a plan, it must stick by the plan that they purchased it by, but also review that. They can review that no later than 2 years after they purchased it to come up with their own plan. It helps them. It provides guidance. And I would agree with Presiding Officer to what Mr Wishall says, is it doesn't increase a greater burden on community bodies than it does on private landowners. And, Presiding Officer, I have to say that I find the comment that community bodies are naturally better than private landowners because they're working for the community is somewhat a strange comment to make. I know plenty of landowners across Scotland who work very hard with their local communities, Presiding Officer. I gave an example at the beginning, which I'm sure Ms Grant will know about, where a private landowner kept open a school which the Highland Council had agreed to close, and the only reason it stayed open and managed to get the pupils it needed to stay open was because of the dedication and commitment of that private landowner. So I think the comments that she's made are totally disingenuous and unhelpful, and I would like to support the amendments by Brian Whittle in this stage. I hope, Presiding Officer, that doesn't jinx them for him.
Thank you, Mr Mountain. And I call the Cabinet Secretary.
I would like to start by saying that when Brian Whittle speaks in the Chamber normally, frequently his contributions are about the need to support rural communities. However, with these amendments, he would place greater burdens on communities than would exist for the largest landowners in the country. And that's where I would agree with the sentiments that have been expressed by Rhoda Grant. Now, the measures that we've put forward in the bill will apply equally. That's to all land holdings over 1,000 hectares. That's proportionate. It's supported by evidence produced by the Scottish Land Commission. Brian Whittle, on the other hand, would like to apply the same measures to any land over 50 hectares which has been bought by a community body. And his other amendments similarly place additional burdens on community bodies for no clear benefit. It is a real double standard that he's trying to introduce here. There is absolutely no reason that we should be asking volunteer-led groups who've taken ownership of relatively modest amounts of land to meet higher standards than those who own the greatest amounts of land in the country. So that's why I would urge all members to oppose these amendments.
Thank you, Cabinet Secretary. And I call Brian Whittle to wind up and to press or withdraw Amendment 252.
Thank you, Deputy Presiding Officer. Can I just say that I think the comments just made by the Cabinet Secretary and by Rhoda Grant at best are anecdotal and not based on any form of evidence whatsoever. The whole point of these amendments was to make sure that land is developed and ownership is developed to the same standard. And at the end of the day, surely that's what we're about. It's not about who owns the land, it's how the land is being used. And quite frankly, as my colleague Endell Mountain said, I found the comments by the Cabinet Secretary, by Rhoda Grant, disingenuous and at best anecdotal. And I will take an intervention. Yes.
Cabinet Secretary.
Amused as to how Brian Whittle could set that out when it very clearly states in the amendments he's bringing forward that he would have on the face of the bill very clearly say that he put obligations on community-owned bodies on over 50 hectares of land. That is treating them differently. Does he not recognise that?
Brian Whittle.
Sorry, it's bringing them into line with the same standards as we have for every other land ownership. It's not putting any more burden on them whatsoever. And again, Cabinet Secretary, quite disingenuous to say that. So I will Presiding Officer, I will move the amendment.
Thank you, Mr Whittle. The question is that Amendment 252 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Martin Whitfield, point of order.
Grateful, Deputy Presiding Officer. I'm not sure if my vote is counted. It hasn't refreshed yet. I would have voted no.
Mr Whitfield, I can advise that your vote was recorded. The result of the vote on amendment number 252 in the name of Brian Whittle is yes 27, no 84. There were no abstentions. The amendment is therefore not agreed. I call amendment 253 in the name of Douglas Lumsden, already debated with amendment 235. Douglas Lumsden, to move or not move?
Not moved.
Not moved. I call amendment 254 in the name of Douglas Lumsden, already debated with amendment 235. Douglas Lumsden, to move or not move?
Not moved.
Not moved. I call amendment 255 in the name of Douglas Lumsden, already debated with amendment 235. Douglas Lumsden, to move or not move?
Not moved.
Not moved. I call amendment 256 in the name of Bob Doris, already debated with amendment 235. Bob Doris, to move or not move?
Moved.
Moved. The question is that amendment 256 be agreed to. Are we all agreed?
Yes.
Are we all agreed? Yes. The Parliament is agreed. I call amendment 257 in the name of Bob Doris, already debated with amendment 235. Bob Doris, to move or not move?
Moved.
The question is that amendment 257 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I call amendment 258 in the name of Bob Doris, already debated with amendment 235. Bob Doris, to move or not move?
Moved.
The question is that amendment 258 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 258 in the name of Bob Doris is yes 84, no 27. There were no abstentions. The amendment is therefore agreed. I call amendment 259 in the name of Brian Whittle, already debated with amendment 252. Brian Whittle, to move or not move?
Moved, Deputy Presiding Officer.
Moved. The question is that amendment 259 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 259 in the name of Brian Whittle is yes 26, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 126 in the name of the Cabinet Secretary, already debated with amendment 235. Cabinet Secretary, to move formally.
Moved.
The question is that amendment 126 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 126 in the name of the Cabinet Secretary is yes 86, no 26. There were no abstentions. The amendment is therefore agreed. I call amendment 127 in the name of Tim Eagle, already debated with amendment 235. Tim Eagle, to move or not move?
Not moved.
Not moved. I call... I call amendment 128 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 128 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Douglas Ross.
I couldn't connect. I would have voted yes.
Thank you, Mr Ross. Your vote will be recorded. The result of the vote on amendment number 128 in the name of Edward Mountain is yes 30, no 81. There were no abstentions. The amendment is therefore not agreed. I call amendment 260 in the name of Bob Doris, already debated with amendment 235. Bob Doris, to move or not move?
Moved.
Moved. The question is that amendment 260 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 260 in the name of Bob Doris is yes 86, no 26. There were no abstentions. The amendment is therefore agreed. I call amendment 22 in the name of Edward Mountain, already debated with amendment 235. Edward Mountain, to move or not move?
Moved.
Moved. The question is that amendment 22 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 22 in the name of Edward Mountain is yes 42, no 71. There were no abstentions. The amendment is therefore not agreed. I call amendment 130 in the name of the Cabinet Secretary, already debated with amendment 235. I remind members that if amendment 130 is agreed to, I cannot call amendment 131 by way of preemption. Cabinet Secretary to move formally. Thank you. The question is that amendment 130 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 130 in the name of the Cabinet Secretary is yes 97, no 16. There were no abstentions. The amendment is therefore agreed. I call amendment 129 in the name of Rhoda Grant, already debated with amendment 115. Rhoda Grant, to move or not move?
Not moved.
Not moved. I now call amendment 261 in the name of Rhoda Grant, already debated with amendment 115. Rhoda Grant, to move or not move?
Not moved.
Not moved. I call amendment 262 in the name of Bob Doris, already debated with amendment 235. Bob Doris, to move or not move?
Moved.
Moved. The question is that amendment 262 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. That's quite good. The vote is now closed. The result of the vote on amendment number 262 in the name of Bob Doris is yes 85, no 27. There were no abstentions. The amendment is therefore agreed. I call amendment 132 in the name of Ariane Burgess, already debated with amendment 116. Ariane Burgess, to move or not move?
Not moved.
Not moved. I call amendment 263 in the name of Rhoda Grant, already debated with amendment 116. Rhoda Grant, to move or not move?
Moved.
Moved. The question is that amendment 263 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Richard Leonard.
Connection error, Deputy Presiding Officer. I would have voted yes.
Thank you, Mr Leonard. Your vote will be recorded. The result of the vote on amendment number 263 in the name of Rhoda Grant is yes, 86, no, 24. There were no abstentions. The amendment is therefore agreed. I call amendment 133 in the name of Rhoda Grant, already debated with amendment 116. Rhoda Grant to move or not move?
Not moved.
Not moved. I call amendment 264 in the name of Mark Ruskell, already debated with amendment 232. Mark Ruskell to move or not move?
Not moved.
Not moved. I would advise members that at this point we will suspend proceedings for a 15-minute comfort break. So you should be back here in 15 minutes. Thank you very much. And to clarify, that means to be back at 18:40. Thank you.